Hi, I'm Pfeffer-Hahn, and today I'm going to talk to you about creating your own will, which is more than just a legal document. It's a testament to your life's work, which is your legacy, and it speaks volumes about your values and aspirations. Whether you're just beginning your estate planning journey or fine-tune your existing instruments, my aim today is to empower you with knowledge, insights, and practical guidance to ensure that your legacy is preserved with the utmost care and consideration. And by the end of this video, you should be able to answer 3 questions, so stick around. Writing a will is going to allow you to have control over your property distribution. With a will, you have the ability to specify how your assets or your property will be distributed after your passing. This includes who will inherit your belongings, your funds, and other kinds of assets upon your death. Without a will, intestacy laws are dictated by the court, typically among relatives according to a predefined formula, often excluding certain people or charities. This means that non-marital partners or stepchildren are often overlooked entirely. Furthermore, in the event that both spouses pass away without a will, the court's going to appoint a guardian for your minor children, and typically they're going to select from among your family members, and it may not be who you would have chosen to raise your children. You should know that property distributed through a will is usually subject to probate, a court-supervised process, and that's going to allow creditors to present a claim against the estate and ensure proper asset distribution to your heirs. So this process can be costly and time-consuming, and in some states, because wills are public record, they may disclose personal and financial details that you don't want to put out to public scrutiny. Consequently, many individuals utilize alternative methods like trusts alongside wills to distribute their property and then effectively can maintain their privacy. As I mentioned before, a will's biggest benefit is for the guardianship of your minor children. For parents with children under 18, a will is going to allow you to designate the guardian or guardians who will care for your children in the event of your passing. This ensures that your children are placed under the care of the individuals that you trust and who share your values. Although you won't be able to speak your opinion, your will always will allow you to clearly designate your preferred guardian and provide reasoning. That's especially crucial if differing opinions are going to arise within your family about who should raise the children. By documenting your preference, you're going to facilitate the court's decision-making process and help your family avoid potential conflicts during a clearly already challenging time. Additionally, a will is going to enable you to appoint a guardian for your children's finances. This individual can be the same person designated as the children's personal guardian or someone else that you entrust to manage their finances effectively. Typically, the court is going to honor your choice for the property guardian unless the named individual is unavailable or unfit. The appointed guardian ensures responsible stewardship of your children's inheritance. Creating a will allows you to avoid intestacy law because without a will, your assets may be distributed according to these state laws, which might not align with your preferences. Intestate succession laws, they aim to distribute the decedent, your estate, in a manner reflective of how the average person might have their estate planned. However, these laws can diverge significantly from your actual wishes for distribution. For example, you may desire to bequeath or give your assets to charities or friends, and they do not attempt to account for intricate family dynamics who may not agree with your choices. By taking the time to write down your wishes in the form of a will, you're going to minimize family disputes. When you create clear instructions provided in a will, you can help minimize conflicts among family members regarding how property is allocated. By outlining your intentions in a legally binding document, you're going to reduce the likelihood of disagreements and uncertainty among your heirs. And like it or not, people will fight about this. Additionally, you get to decide who your executor is, and they're going to be responsible for carrying out the instructions that you've outlined in your will. This individual is going to ensure that your wishes are implemented effectively and that the probate process proceeds through smoothly. You should choose very carefully the person that you want to do this, because no matter what the size of your estate is, your executor is generally responsible for carrying out the following things, and some of it can take a lot of time to handle. They're going to be managing your estate, which can include taking an inventory of your assets, protecting certain property, or selling certain property. They're going to represent your estate in any probate proceedings, which includes filing the will with the probate court and determining whether the estate is eligible for a streamlined probate process. They're going to determine who your inheritors are and properly distribute assets to those inheritors. They're going to pay your debts and taxes, including notifying creditors of the probate proceedings and filing a final tax return on your behalf. They'll also be setting up bank accounts for any money that's owed to you and delivered after death, such as final paychecks, stock dividends, or payment of debts that are owed to you. They're also going to pay any ongoing expenses, such as making payments on utilities, your mortgage, or insurance premiums, not life insurance, until the probate is closed. Your will is also used for tax planning. This way, you are potentially minimizing the tax burden on those that you're going to give to and maximizing the inheritance received by your beneficiaries. With careful tax planning, you can also reduce your tax bill by utilizing deductions, credits, and other tax-saving techniques. This is going to enable you to allocate more funds towards your financial objectives and your family instead of paying it to the government. So overall, having a will provides a certain level of peace of mind by allowing you to control who gets your assets, protecting your loved ones, and ensuring that your legacy is carried out according to your wishes. Now for your 3 questions. Who decides who raises your children if you don't have a will? How is your property assigned if you don't have a will? And why is choosing the right executor so very important? Thanks for watching Finances and Writing Your Will. I'm Kathy, and I'm grateful to be a part of your journey to your financial empowerment. Please let me know the topics that you'd like covered in the comments. And for those of you who've already subscribed, thank you. But if you're new, please subscribe so that you too can improve the way that you think about your relationship with money.